Okay, so welcome back to the channel. It's me, Kristofer Brooks, and I hope everyone's well today. As you know, I have been communicating back and forth with Companies House regarding this ridiculous, what's it called? Hang on, let me see if I can find it. The new Economic Crime and Corporate Transparency Act 2023, also known as the ECCTA. Anyway, I recently wrote to Companies House about the director identity verification under ECCTA 2023. I sent a formal signed letter by recorded delivery, but their response shocked me. And I know you've already seen this letter because I've already showed you. But just to recap, instead of providing a proper reply, addressed and signed as you would expect it from a statutory body, I received an unsigned, unattributed email. That raises serious questions to me. Serious questions about transparency or lack of, as to accountability, and of course, let's not forget due process. Let's not forget this is a government agency demanding strict compliance and threatening criminal penalties, yet it fails to meet the basic standards of public administration itself. Today I'll walk you through my response in the letter that I sent and why this matters for every UK business director or any business owner and company secretary for that matter. Just to give a little bit of background on this for those who aren't familiar with what I'm talking about, and just so you get a better understanding of what these identity verification rules are about. So, and I'm reading now. Under the Economic Crime and Corporate Transparency Act 2023, every person with significant control and even anyone who files documents at Companies House will soon be legally required to complete identity verification. This can be done in two ways, either directly with Companies House through their online system or through an approved accountant, solicitor or company service provider who is registered as an authorised corporate service provider. So if you're a new company director, you'll have to verify your identity before you can officially take up that position. If you're an existing director, you'll need to verify within the transition period, once Companies House opens the system. And these penalties for not doing so? Well, they're serious. You can face fines, restrictions on your company filings, or even criminal liability if you were to fail to comply. The government says that this is about tackling fraud on fake companies. But I'm pretty sure if you speak to Gary Waterman. But as you'll see from my experience, the way Companies House is handling communication raises major concerns about fairness, transparency and accountability. If you're a company director, an entrepreneur, I can never say that properly, or anyone interested in the new Company House rules, this is the information you need to hear, and why we must hold our public bodies accountable to the same standards they impose on us. So stick around, I'm going to read out my formal letter with my other voice, which I hope pulls no punches. If you've ever felt that Companies House, or any regulator, doesn't play by its own rules, well then hopefully this will resonate with you. Let me know what you think in the comments, look after yourselves, and I will speak to you all again soon. Bye for now.
Dear Chief Executive, I write in respect of your email of 15th of July 2025 concerning the Economic Crime and Corporate Transparency Act 2023, ECCTA 2023, and the new Identity Verification (IDV) regime for directors. That correspondence was issued by email only, not addressed to me personally, unsigned and unattributed to any officer of Companies House. For a statutory registrar to communicate in this manner on matters that impose criminal liability upon company directors is wholly unacceptable. It undermines confidence in Companies House as a public authority, contravenes established standards of good administration, and may constitute a breach of your public law duties. 1. Statutory Framework ECCTA 2023 Part 1, Chapter 1, SS 63-71 imposes mandatory IDV requirements on directors and officers, backed by criminal sanctions for non-compliance. Companies Act 2006, S-168, requires Companies House to carry out its statutory functions in a way consistent with the law and published regulations. Where sanctions attach, public authorities must act with the highest degree of procedural fairness and transparency. CRV Secretary of State for the Home Department, XP. Duty, 1994, 1 AC 5 and 31. Number 2. Administrative Law Principles. The present conduct offends the following principles of public law: Legal certainty, RV SHD XP Pearson, 1998, AC 5 and 39. Individuals must be able to clearly understand their obligations and liabilities. Procedural fairness, duty. Persons subject to statutory obligations must be given clear notice and reasons. Reasonableness, Associated Provincial Picture Houses v. Wednesbury Corporation, 1948, 1 KB 23. Actions that no reasonable authority would take are unlawful. Proportionality, R. Daly, for Secretary of State for the Home Department, 2001, 2 AC 5 and 32. Restrictions or burdens must be proportionate to legitimate aims. Effective notice, Anna Frajeva of SSHD, 2003, UKHL 36. Decisions with legal consequences must be properly communicated. By issuing unsigned, unattributed communications, Companies House risks breaching these principles. The three public standards. Companies House is bound by the Nolan Principles of Public Life, accountability, openness, integrity. The Civil Service Code, requiring honesty, objectivity, integrity, and impartiality. The Parliamentary and Health Service Ombudsman's Principles of Good Administration, clarity, accountability, fairness. Your email fell far short of these obligations. 4. Formal demands. I therefore require that all future correspondence be properly addressed, signed, and attributable to a named officer. A corrected, formal response be issued compliant with Companies House's legal and procedural duties. Clarification be provided with legal certainty on the scope of IDV obligations, SECSS 63-71, including whether transitional provisions apply to directors appointed before commencement, the procedural framework governing IDV, how notices will lawfully be issued, what constitutes valid compliance, and statutory timelines. The safeguards for fairness, ensuring no director or company is penalized due to delay, ambiguity, or administrative failure by Companies House. 5. Escalation. If a signed, substantive response is not provided within 14 calendar days of receipt of this letter, I will pursue the following remedies without further notice. Internal complaint under Companies House's formal procedure. Referral to the Department for Business and Trade as sponsoring department. Complaint to the Information Commissioner's Office, ICO, if Companies House continues to communicate without attribution. Raising data accountability concerns. Referral to the Parliamentary and Health Service Ombudsman via my Member of Parliament. Judicial review proceedings on the basis of procedural unfairness, unreasonableness, Wednesbury, breach of legitimate expectation, and failure to comply with statutory duties. 6. Conclusion. The obligations imposed by ECCTA 2023 are significant, novel, and carry criminal consequences. It is therefore imperative that Companies House demonstrates full transparency, accountability, and procedural integrity in its dealings with directors and companies. I expect your immediate attention to this matter and a substantive reply, properly signed and attributable, within the timeframe specified. Yours faithfully,